Hi, it's a new day. Welcome to session 10. We've gotten through the really hardest parts of it, which really is the discovery and the mediation parts of it. Now we're just smooth sailing through the rest of this. The other sessions are going to go a lot quicker, so let's get started. We're on the top of page 35. Let's turn there in our workbooks, and we're at the part where it says final trial. If you don't settle in mediation or otherwise come to an agreement. If you don't settle in mediation or otherwise come to an agreement. Okay, so the bullet point there says final trial. When you need a final trial date. The first check mark says if you don't settle in mediation or come to an agreement with your husband. So that's pretty straightforward. Next is find out from the court coordinator or the court administrator. That's usually the person who is the right-hand person of the judge. They do all the scheduling. They do all the administrative stuff. So sometimes they're called court coordinators. Sometimes they're called court administrators. Or in your area where you live, they may be called something slightly different. But just know it's that person who does all the scheduling, does all the judge's calendar. Okay. So find out from the court coordinator or the court administrator if you can set a trial date before you have mediation. Now, a lot of times you can't do that. Some places you can, but a lot of places you can't. They want to have every incentive possible for you to settle in mediation. So they say, you know what, we're not going to make it easier for you having a final trial date before mediation. We're going to make you go to mediation first and then set a final trial date. So those are one of the things that you can ask. And sometimes it is different in every single court within the same courthouse. So, one judge may say yes, one judge that hears family law cases may say, yes, you can set a mediation date. The judge right down the hall may say, no, that's not our policy here in this courtroom. So just know it can vary within the same county. Okay. Next one says, or if you can't do it before mediation, set a date right after mediation. Make sure, because a lot of times final trial dates, depending on how congested the court calendar is, it can take, up to 4 to 6 months out for you to be able to find a date. And know that final trials take place in a public setting. Anybody can walk into the courtroom and sit down and watch and hear everything. I know some people kind of get flipped out by that, but that's absolutely true. Unless there is some type of specific reason that you can have a closed court. Most of the time, most people don't fit that criteria. Last check mark on that page says, usually the judge decides your case, but in some states, you can request a jury trial. And you can look up the rules whether they allow that or not in the county or the state that you live in. You can find that out in the law library. And most of the time, most people just want what's called a bench trial, which means that the judge makes a decision from the bench. They don't want a jury. If your state allows it, most of the time you don't want that. Okay, because you may be your neighbor down the street that gets the jury summons, and you're like, oh, it's Mr. Simmons from down the street. He's gonna possibly be hearing about my divorce. Anyway, okay. Top of page 36. The check mark says you need to get witnesses lined up, and that's if you need witnesses. So say, for example, again, if you're not doing something that's, no fault and you're trying to prove, your ex had an affair, your ex stole money or spent money on, the girlfriend, and, all of those things, say for example, okay, let's just use that example. Let's just say, your ex has a girlfriend and, he spent, $20,000 on her. You're like, you know what? You're going to pay that back. So you're going to need some type of witnesses, or you're going to need documentation, to be able to show that that's what happened, and so because most of the time they're not going to admit to that. You're going to have to show evidence. Next check mark, that's exactly what we're talking about. You need to get your documents or evidence lined up that you want to have the judge look at or admitted into evidence. And sometimes, again, that can be tricky. Sometimes you'll get that evidence through subpoenas, and there may be certain forms that go along with subpoenas. They're using Texas as an example. Texas has something called an affidavit for business records, or a business records affidavit. And that is something that there are people who are called Custodian of Records. Custodian of Records. And they are the people who are obviously responsible for keeping the records. They're custodian records for hospitals, for banks, for just about anything that you can think of that has a fairly large volume of records that they have to keep. And so if it's a mom and pop business that you need, for whatever reason you need business records from, then you probably just get it from the owner. But otherwise, if it's a big institution like a bank or a hospital or something like that, or a school, they'll also have a person who is specifically designated to take care of those records. And you usually ask that person to sign that affidavit, and they may have something very similar in the state that you live in. Again, in Texas, it's called an affidavit for business records, and you want that person to sign that because when they do, they swear that the copy that they're handing the judge is exactly what they have. In other words, there's no question that you went in, and took out records, or printed out something from your computer and stuck it in there. No, it usually gets there sealed in an envelope, and the judge is the person who opens it up. Now you can obviously get a copy for yourself and be able to get copies to prepare for final trial, but the copy that the judge sees usually is a sealed copy that the judge ends up opening up the envelope. Okay. Write down ultimately what you want out of all of this. What can you live with? What are your deal breakers? What is your drop dead deadlines, or all of those different things. Really figure out what those things are, and really have that set in your mind before you get to final trial. And again, usually final trial, if you're at that point, is something that you need an attorney's help, especially if you think you need to call witnesses. Let's say, for example, you don't want your soon-to-be ex to have overnight visits with your kids until they're older, and you need to speak to the teacher who was the one that your ex forgot to pick up your child from school 5 times in the past 3 months, and the teacher's like, well, it was his his time that he's supposed to be with the kids, and he didn't pick them up. So if you need that teacher to come in and testify about that, then again, you usually need the help of an attorney. Okay, so that's session 10. Let's move on to session 11.